further ado, Philippa, the mic is yours.
Thank you so much, Mia, for that lovely introduction and really thorough kind of setting out the issues. It's a real pleasure to join you all, and thank you for taking the time out of your evening to come and listen today. I have to say, I haven't got any hummus out on the table, but I can definitely provide some fairly solid human rights chat. As you can see here, this cartoon just speaks volumes for me as somebody who during lockdown was working from home and in fact wrote a blog about the challenges of working at home, although I have to say my editors were much more pleasant than the lady on this particular cartoon. Oh, and now my tech doesn't work, of course. There we go. So this is me. My topic for this evening is home working, surveillance by software and the right to privacy. As Mia said, I'm a specialist in labour law and human rights. So I'm a researcher rather than a practicing lawyer. So basically that means that I think far too much about these sorts of things. So if I am going too quickly or if you've got any questions, then please just ask at the end. So the outline for the talk I'd like to give this evening, first talking a little bit more about the context of working from home during 2020, talking about surveillance by software, and particularly a story shared by a New York Times journalist, Adam, who in fact used these surveillance techniques on himself to see how it felt as a worker. Then I'll give some more detail to the right to privacy itself and Article 8 of the European Convention that Mia mentioned at the start. And think then finally more specifically about workers' privacy rights in the UK and how they're protected. And hopefully that'll take me about half an hour, but we'll wait and see. So, working from home in the UK. So down the right-hand side of the slide are a number of quite fairly large companies, global companies, that are considering either a partial or no return from to work in an office, in a central office. And those have been announcements that have been made during lockdown, particularly, for example, Google. Very, very quick turnaround, 180 from wanting all of their employees to be in their big offices in America, and now they're actually saying that they're willing to offer much more flexibility. So from our 2019 statistics in the UK, only 5% of the workforce worked mainly from home. Fast forward to May 2020, when we were in the first lockdown, 44% of adults surveyed were working mainly from home. So a really dramatic and rapid increase. Kind of a couple months further through, so we're now out of the first lockdown, but before the second, in September 2020, 64% of adults had travelled to work in the last week. That doesn't tell us how often they're travelling to work. So it may be that they're only going in, say, once a week to reduce their contact with others. But still, that's much, much lower than the kind of 95% that would have been doing it in 2019. And then in October 2020, I've drawn on an Institute of Directors survey, which was of almost 1,000 firms in the UK. 74% said they wanted to maintain an increase in working from home, and kind of those big companies that I mentioned earlier would be probably considered within that group. And 50%, so over half, said they were going to reduce their use of kind of centralised office spaces or workplaces. So really interesting context and a rapidly changing one. I mean, now we would be much more looking like the statistics in May because we are in kind of lockdown 2.0. So I actually think of kind of working from home and this sort of area of work as more of a spectrum. So it's easy to kind of distinguish between people who go to an office and people who kind of work remotely. But there's probably much more of kind of shades of grey between those two groups. So on the left-hand side, the central workplace group. So those are the people that during lockdown were suddenly asked to work from home where at all possible. So they have gone from being very centralised, going into work often most days of the week, or only working from an office or a centralised workplace, and then suddenly during the first lockdown, and indeed for most people during the second, they are now being asked to work at home if possible. The other two groups were already within the workforce. So there are a group of people who have a mix. So they sometimes go into an office, but sometimes are used to working from home. I would probably count myself within that group, because as an academic, I obviously go into a university and teach, but I also do work from home, for example, when I'm researching and all I need is a laptop and a couple of books. At the other end of the spectrum are remote workers. So these people are hired and operate fully remotely. They don't have a centralized office. So these might be the people that you've heard of in the media who work from coffee shops, who can kind of work wherever they want all over the world, but they work for the same company. They just have a very remote working relationship with that company. It's particularly prominent, I would say, from kind of anecdotal evidence in tech sectors where it doesn't really matter where you're doing your work, because all you need is your laptop and your tools via the internet, for example. So it's not as clear cut as either you work from home or you don't. There's a lot of kind of degrees of difference between different parts of the workforce in this regard. But obviously the interest has kind of ramped up in recent months, because suddenly we had a huge population that were being asked to work from home, having been not used to it previously. So working from home or remote work, so those kind of more established categories who we've kind of had in the workforce for a long time, this is not a new phenomenon. So it's worth, as kind of a labour lawyer, or when you're thinking about this, is acknowledging first that this isn't new. We've been doing this for many, many decades. Think about people who, for example, used to take in sewing to their homes and then give it back to the client or customer. That is a form of working from home. It's just a very different form to the one that we see more prominently now. So you can see in 1996, there was an ILO convention on homework. So in that kind of pre-existing debate, working from home or remote work is often considered quite a popular option for workers, because particularly they get a flexibility. So they get a flexibility of working time in terms of each day they can fit their working patterns around their other responsibilities, particularly caring responsibilities. There's no commute, so maybe quite a few of the audience might live in London and know exactly the pain of a lengthy commute when you're living in a big city to get into the central areas of the city. Obviously, if you're working remotely, that commute is completely removed. And now we could also add environmental concerns to that as well. And in terms of particularly remote work, as an employer or as a worker, you're looking much more at global opportunities rather than local ones. So you could live in London, but work for a company in LA, and that would be completely fine. So it almost opens up the market and the labour market for opportunities in both directions to hire kind of the really best candidates and to find the job that best suits you. That's not to say that there aren't some risks. So I think most people who have been working from home intensively in the last 6 months would recognise the risks around particularly social isolation and the challenges that come with that in terms of creating a sense of community or effective teamwork once you're kind of thinking about actually operating as an individual employee. There's also been noted a concern about work intensification and a lack of separation between home and work. So I don't know if anyone else shares this experience, but when you work mostly on your laptop and your laptop is still there once you've watched your episode of The Crown at 9 o'clock at night, there is always that temptation to open the laptop up and respond to a couple more emails. That's just a really straightforward example of how home working can really quickly intensify the amount of work that you're doing over time, and it almost completely abolishes the separation that we're used to between our workplace and our home spaces. And then add to that a pandemic. So now we are not working from home, we're working at home, where we were previously obviously used to working in kind of a centralized space. So you're facing a very sudden transition. So we might be fairly poorly prepared for that quick transition from working centrally into working independently in our homes. You layer on the context of the pandemic, where initially we had schools that were closed, people were battling, kind of balancing their caring responsibilities either to younger or other family members. And there was also an issue around limited social interaction as a result of the pandemic restrictions. And then particularly, I think, prominent discussions around young families about having very limited or small communities of support, which previously, if it wasn't a pandemic, would have been really thoroughly engaged in caring for example, a newborn. I know for people my age, that's been a conversation that has come up time and time again. We have obviously a fairly significant impact on mental health and well-being during this time that has been probably intensified by working at home. And then thinking more from kind of a worker and employment perspective, the working environment is probably not ideal for most people. A lack of a space that they can go to kind of be productive and to be in a quiet space away from other what might be distractions, but also, you know, dogs, cats, children, auntie, you know, all of that stuff. So lots of people don't have the capacity to shut the door in their home and have a productive space. You might also not have the required equipment or technology. So I don't know if people have been on these Zoom calls where somebody's Wi-Fi is really poor, and that means you can't really get a decent conversation going. That's been fairly systemic across all of the lockdowns that I've experienced. And then the working systems, what we rely on to actually do our work in terms of particularly collaboration and information access. Now we've had to very suddenly transition from having shared spaces together and daily contact to being completely apart and not even able to meet up for coffee, particularly for some periods where the lockdown restrictions were stringent. From an employer perspective, there's always been a bit of a concern about working from home because it is perceived to impact negatively on their workers' productivity. So this was the kind of slowing factor on employers embracing working from home before the pandemic. They're worried that they might not be able to supervise their employees effectively, and they're worried that they might not be able to maintain a comparable level of productivity once their workforce is spread across their homes. There's definitely an ambiguity around the actual impact on productivity that we see when people have been working from home. So reports from a study done by the Universities of Cardiff and Southampton took surveys during April, May and June. And that what they were asking was, particularly for the June survey, they were asking people to compare their productivity in June to the previous December, so December 2019. And what was really interesting is that 41% of people said they got more work done whilst they were working from home. Oh no, sorry, 41% said they got as much work done, so staying pretty much the same. 29% said they got more work done. And particularly I would probably highlight the commute time as time that is being won back as a result of working from home. But then 30% did report that their productivity had fallen. And we might note that there might be some pandemic factors that we have to take account of there in terms of, for example, caring responsibilities impacting your productivity. But that's the kind of employer's perspective on all of this. So what do we see once we go into the pandemic and everybody is working from home? We see an enormous increase in demand for software packages that can monitor your use of electronic devices and create what's called productivity scores for the individual whilst they are working. And so there was one report that I quote in my blog, 71% higher demand than pre-pandemic levels for a couple of the software. So that's an enormous increase in the demand for this kind of software. And down at the bottom is a couple of examples of the kind of big name brands. Hubstaff is one that I'll talk about a lot, but all of these are used across the UK, America, and so forth. So Hubstaff, I recently read a report, is installed on 100,000 company machines globally, which is a huge number, and that's only one piece of software. So what are these software packages actually doing? So there's a couple of possibilities that I've seen reported. So a very low tech option, if you are familiar with Zoom, for example, is to just ask your employees to open a Zoom call and have it open all day. And you can just sit, and if you're the manager, you can just check quickly where they are, what they're up to, and if they're in front of their laptop. Not sure I'd be thrilled if my boss decided that that was the approach he was going to take, but it's definitely something that has been reported fairly widely, in fact, in the UK during the pandemic. More high-tech options, so the things that those brands that I showed you might integrate: tracking your email traffic and even content, tracking the keystrokes on your laptop keypad, taking what's called staggered screenshots, so forcing your camera to take a screenshot of your screen every 10 minutes. So you can see exactly what an individual is doing on their screen for the whole of the working day. So, you know, if I had a screenshot now, it would show this presentation, your lovely faces at the top, and it would keep doing that until my laptop closed. Task by task productivity monitoring, so tracking how long am I typing on my Word document, how long am I actually just wasting on Facebook. All of that sort of stuff can be monitored by looking at what you're doing with your laptop and what websites you're looking at, who you're talking to, and so forth, to try and work out what time is productive time and what time is deemed unproductive. They can also integrate location tracking if the same piece of software that's on your laptop is installed on your mobile, so it can use your mobile GPS. Website tracking, as I mentioned, is completely possible and actually probably fairly easy, as well as integrated social media monitoring. So you could, for example, see what your employees are tweeting at any time, not just during the working day. Possibly most concerningly, some of these pieces of software have covert capacities, so they could be installed particularly on a company computer without your knowledge. So you could be being monitored and not actually be aware of it. I can see some possibly slightly concerned faces. Now I've outlined the true capacities of these kinds of pieces of software, but you can see, so these are just a couple of fairly recent media reports. So Barclays had a fairly aggressive monitoring system that got removed because after actually only under a month, because there were so many employee complaints. The Guardian reporting that we are feeling the heat as bosses ramp up remote surveillance. And the last one is a BBC News article that, after I'd written a blog about this topic, got sent to me about 20 times because people knew that I would be interested to hear about it. So that is a boss using Hubstaff, the piece of software that I'll talk about in a minute, to take screenshots of their employees during the working day. So that links nicely into Adam's story. So he's a New York Times journalist and he was investigating this issue. And he's far braver than me because his solution was to turn Hubstaff on himself. So he downloaded the app on his laptop and on his phone. So what was it doing? It was taking those regular screenshots of his laptop. It was tracking his GPS location and also producing a productivity score, which was measured by how much time he spent typing or moving his mouse, which to me, quite a random measure. And it also produced a daily report to his manager, which was then sent to his New York Times manager, which included the websites he'd visited during that day. Initially, Adam's really disappointed by his productivity scores. And he reports how the monitoring starts to affect his behavior. So he stopped using particular messaging apps on his laptop because he was aware that private conversations could be screenshotted, and therefore, you know, his correspondence private information would be shared with his boss as a result of Hubstaff. It also captures a screenshot of an exercise class. He's in a kind of shared living space, so you can see his children are in the room in the background if it's taking a camera picture of him from his laptop. a GPS of his jogging, of his trip to the wine shop, of his family trip to the park, because it's on his mobile as well. So when you're carrying your mobile, hub staff knows where you are. Towards the end of the piece, you start to see his boss say, actually, I stopped checking the reports because I've just found them not very useful. You know, it wasn't useful information and it didn't help me judge what Adam was actually up to in terms of his work. And eventually Adam starts cheating the system. So if the laptop is taking screenshots periodically, he would leave work documents open whilst he went and made a coffee, because that would make it look like he was working, because there would be a Word document open that, you know, he would be working on. So it's a really interesting story to show how it affects your behaviour, what anxieties start to come out, and how you actually can start maybe gaming the system when you're subject to these sorts of productivity measures. So kind of when I look at this as a kind of human rights employment lawyery type person, this is a whole range of privacy concerns that need to be unpacked and need to be discussed. On the worker side, there's obviously your own right to privacy, to your image, to the control of the information about yourself, to develop relationships with others, and also where you are. You know, that could be seen as private information. And there's your own right to your family and private life. So particularly maintaining some time away from work and free from supervision of your employer. I think possibly almost uniquely for this type of monitoring is that it also affects the rights of your close connections. So your partners, your children, your housemates. And they might be in the background of the shots that are being taken of you by your laptop. Other forms of data might be disclosed almost by accident. And they kind of just have a right to be free from this kind of intrusive surveillance measure that I think has been neglected in the discussion so far. We also might think about other types of human rights as well. How does this sort of monitoring affect your expression, your opinions, your association, and how you express those in your daily life? So that's all of the kind of concerns that I can think about from the worker side, and I'm sure you might be able to think of more. On the flip side of the debate, the employer, what are they up to when they're doing this sort of monitoring? Well, they need to run their business. That's kind of the core of what they're up to. They need to stay in touch with their teams. They need to coordinate work across different individuals who are now separated and working from home. They might also be interested in monitoring your conduct and your performance in your job. Whether you think it's an accurate way of measuring those things is a different question. They might be monitoring the use of the company's time, of their equipment, or their information. So particularly issues around sharing of confidential information or proprietary information might be used to justify these kinds of surveillance measures. So looking at those security concerns could add a level of justification for these types of monitoring measures. I'm just going to take a brief interlude because if Radio 4 can get this wrong, I think it's worth clarifying. On the bottom, in the blue, is UK law and the UK court system, including England and Wales, Scotland and Northern Ireland, okay? And I want to keep really, really separate two things. In the purple is the European Union. It has things like treaties and regulations and directives, and it is regulated and decisions are made in that system by the Court of Justice of the European Union. So we know this is where Brexit is. The European Communities Act is what joined us to the European Union, and the European Union Act of 2020 is what will take us away. In the green is the stuff that I'm going to be focusing on today. Notice how I'm really cleverly avoiding talking about Brexit, which is always good because Brexit's really complicated. So on the green side, you have the Council of Europe, which is the body that produced and kind of maintains the membership of the European Convention on Human Rights. The body that makes decisions about the content of the European Convention and how it applies in particular cases is the European Court of Human Rights. It's really important to keep those two systems separate, and often our media will confuse the two. So that kind of adds a little bit less clarity to the debate than is desirable. What links the UK system to the European Convention is the Human Rights Act. I'm sure everybody really knows this, but it's worth just taking some time to remind ourselves. So we're talking about that green side, the Council of Europe, the European Convention, and the European Court of Human Rights. Particularly, we're talking about Article 8. And if you haven't read Article 8, either in a while or even ever, I would understand, but this is the full text of the article that we're talking about. So you can see the first section has the right to respect for your private and family life, your home and your correspondence. And the long bit is what's called the justification process, or the qualifying process. And I'll explain that a bit more in a minute. But it's important to note that this isn't an absolute right. You know, it's something that can be restricted if it's in accordance with law and necessary at a democratic society. So in that way, it can be contrasted with other rights. For example, the prohibition on slavery is an absolute right that cannot be justified or restricted. So, as I said, this is a qualified right, what's called the right to privacy, which is the kind of the Americanized language. That means when we're looking at Article 8, we're going to be engaging in a two-stage process. The first stage, has there been an infringement on the individual's Article 8 right? And I'll tell you a bit more about that in a minute. And then the second stage is the kind of meaty bit, a bit where lots of the work and a lot of the analysis is actually done. And there are three main parts to that. The first thing that the court has to do is check that the measure itself is lawful. It's in accordance with law in the relevant jurisdiction. So here, when we're talking about the right to privacy, one thing we might want to consider is the Data Protection Act, which is obviously quite a detailed piece of legislation that would be relevant here. The second part is asking whether the measure or infringement pursues a legitimate aim that is set out within the text of Article 8.2. So there's a couple there. Protection of the rights and freedoms of others is one of the main ones that we see in the employment context, because you've got two competing sets of rights kind of going head to head, the employer and the worker. And then the third element is asking whether the measure or infringement was necessary to achieve that legitimate aim. So once we've said what we're going to achieve, is the thing that we've done actually necessary to achieve that aim? And I'll talk about that in a second. But that is how the right to privacy basically works in the European Convention. It's not a complete right, it can be restricted, but the restriction process is going to be examined fairly carefully by the Strasbourg court. So if we go back to Adam, because my brain only works with kind of a concrete example. So say Adam gets fired. This is obviously all hypothetical. He gets dismissed because his productivity falls too low or it's behind his colleagues. And the data that they use to reach that conclusion is data from Hubstaff, the app that I described. And they use that during the course of the investigation and to kind of demonstrate why he's been dismissed to Adam and potentially to the UK courts. In order for this to reach Strasbourg, he's going to have to lose his case before the UK courts. Basically, you only end up in the European Court of Human Rights if your domestic system has failed you and failed to protect your rights properly. So in our jurisdiction, the most likely thing I would say is that he would try an unfair dismissal complaint. Okay, and then he'll lose that and then go up to the European Convention Court. So before the European Court of Human Rights, he would probably say that the monitoring that has been used on him is a breach of his Article 8 rights, and the fact that he was ultimately dismissed is kind of the cherry on the dismissal horrible cake. You know, he's both been subject to these measures and then dismissed on the basis of them. So it's a fairly severe infringement. So the first job for the European Court of Human Rights would be to ask, has there been an infringement? Has his Article 8 right been infringed? And you can see from this slide that a huge number of different interests and rights are protected within Article 8. It's a fairly broad definition that captures a lot of different things. So developing relationships with others, the right to personal development, to live privately away from unwanted attention or publicity. We can see how those would definitely be relevant to Adam's case. To maintain and develop a social and intimate life, to have the rights to one's image, so thinking about, for example, press infringements, the right to your image is important there, to protection of physical and psychological integrity, peaceful enjoyment of one's home, which we must note is very broadly defined by the European Court of Human Rights, and to property in kind of the legal sense of property. And also, if we're thinking about emails, you have a right to privacy in correspondence and also privacy in your own personal data. So you can see that's a huge range of rights that might be invoked to support Adam's case that he has been subject to an infringement of his Article 8 rights. And on top of that, it's actually taking place within his own home. And I would say that makes it even more likely that he will have a successful argument on Article 8 grounds. And he has what's called a strong, reasonable expectation of privacy in this context. So we're going to zoom through to the end of the debate, because that's probably where most of the analytical work is done. We can assume that it will probably be just about lawful within the UK, and that the legitimate aim would be to protect the business interests of the employer. So how is the Strasbourg Court going to weigh up the two sets of rights, of Adam's privacy right against the employer's kind of right to run their business, or their right to protect their time, for example? So one thing that they're going to be really interested in is whether Adam has been told in advance about the nature of the monitoring. So when I mentioned covert monitoring, that's only going to be acceptable in very narrow kind of situations. And what is the extent of the monitoring? That's going to be something that the court's really interested in. Is it monitoring, when an email is passed between two people? Or is it actually monitoring and reading the content of the email itself? Is it looking at traffic, or is it looking at content itself? When is it happening? How much time are you being monitored per day, and where? Which locations? We saw that Adam was being monitored both in his home, but also when he was walking around and kind of engaging in what might be considered private activities. I'm not sure I want my boss knowing when I go to the wine shop. So the more aggressive the monitoring, the more interested Strasbourg is going to be. And the weightier the justification, the stronger the justification needs to be in order to justify the monitoring and the infringement on his Article 8 rights. Looking more towards the end of the slide, are there any alternatives that the company could have used in order to achieve the same goal? Were there other measures that they could have taken to make sure that Adam was productive? Honestly, the answer is probably yes. What are the consequences for the employee? So I said in my hypothetical, Adam's been dismissed. We know from ECHR jurisprudence that that is considered a really serious infringement on your rights. So again, the court is going to be really seriously scrutinising the measure that's in place. And this one is also regulated by the GDPR, but is your monitoring being used within or beyond its original purpose? If you're using the monitoring data outside of what it was originally intended for, then that's going to be quite dodgy, both legally and in terms of the necessity factors as well. And what kind of safeguards did you have in place? Did you have policies and documents that really clearly explain to your workforce how that you're going to use this data and what purposes you're monitoring for and what the consequences might be? And also, I think they would be interested to see if the individual had a right to challenge what data had been collected about them. So say if you thought the data was inaccurate, that might be something that would be considered here as well. So all of these could be issues that the court would be considering relevant when it gets to the level of the European Court of Human Rights. You can see it's a fairly extensive list, and actually it covers quite a few factors that I think are really important. And broadly, I think the European Court of Human Rights has got it right. So just to wrap up on Article 8, so this is the kind of international, the European side of things. To the extent that we have one, it definitely grants us the right to privacy. As I said, the right to privacy is really an American kind of phrasing of it. So we have the right to respect for our private and family life and blah, blah, blah. But if you were going to find a right to privacy anywhere in our setting, it would be in Article 8. I would say there's a fairly fair framework which we can use to balance between the two sets of rights and interests. So on the one hand, the worker, and on the other, the employer. Obviously, if you read enough about these cases, you will find people who are criticising how the framework has been applied in particular cases. And if you want, I can kind of point you towards some of the more controversial ones. So that's what we have in terms of kind of European human rights law under Article 8 relating to workplace surveillance. But how do we translate that into rights a bit closer to home, so workers' rights in the UK? On this jazzy slide, I really wanted to put the Data Protection Act in bold. I can't emphasise how useful and important the Data Protection Act is. And you can, I think Mia's going to distribute my slides, you can click through to look at the Data Protection Act itself. And also there's really useful guidance from the ICO, which is the body that enforces and investigates data protection issues. That's a really important set of rights that can be really powerful if they're deployed well by the individual. You can challenge a lot of issues around how your data is collected, stored and used under the Data Protection Act. And that applies as an individual, but also as a worker as well. And we're starting to see those consequences through litigation. Other more kind of indirect or tangential forms of protection that we might think about. So there's the Equality Act, which protects us all from discrimination. So a sort of overlap between the right to privacy and not being discriminated on the grounds of your sex or sexual orientation or on gender reassignment grounds. So there is a sort of overlap there between Article 8's concerns and the Equality Act. As I mentioned before, probably more generally used is the law of unfair dismissal. So in this country, every employee who's been in their job for a certain amount of time has the right not to be unfairly dismissed. And now we know that we need to layer on a set of convention concerns. So the European Convention of Human Rights can be used in unfair dismissal litigation to try and persuade the judge that maybe your dismissal was in fact unfair. You might also think about using the rights contained in your contract of employment or other contracts for work. There are lots of implied terms that can be quite useful, although that argument hasn't been tested very extensively yet. And if you're employed by the state or local authorities and things like that, you could also think about doing a judicial review case where you would be relying directly on Article 8 itself and suing essentially your employer as a government. So there are options there. It's not kind of perfect by any means, but there are some very powerful tools at our disposal as workers in order to protect our privacy rights. That's it from me. Thank you very much for listening. I put the little cocktail glass because I'm sure there might be some maybe gin and tonics happening after my talk. But if you do want to get in touch with me or kind of keep tabs on what I'm up to, I'm on Twitter there. And obviously, as Mia mentioned, I'll be at the University of Bristol in January. Maybe I'll even manage to come to the René Cassin, actual physical offices in London. That would be exciting after the pandemic is over. And also because I'm ever the lecturer, if you want some further reading, which I always like to set my students if they want to kind of learn more about a particular topic, I've put some resources there that are kind of related to the topics I've just been talking about. The Labour Law blog was kind enough to publish my blog on privacy at working from home, as well as my colleague Elaine's. There was a really interesting BBC interview with Adam that I mentioned, who turned Hubstar on himself, talking about how he felt, and also his boss is included in there as well. There's a really great podcast with Michael Ford on the Oxford Human Rights Hub, which talks very specifically about COVID and workers' rights. I would recommend, if you are interested in data protection, the ICO has a phenomenal set of resources and they've produced dedicated resources on data protection and working from home. And the European Court of Human Rights must know that we're interested in this topic because they've produced a really excellent summary of the case law that they've decided on these issues. So Mia's going to distribute these. You should be able to just follow those links if you're interested in taking this kind of interest a little bit further. Unless there's any request to see any slides again, which I'm more than happy to zoom back and show some slides that I've already gone through. I'll stop my screen sharing so I can see more of your wonderful faces. Do I need to zoom back to any slides? No. Okay, let's stop sharing.
That was brilliant, Philippa. Really, thank you. And if my staff member were joining us this evening, they would testify that I don't use any of that surveillance software. I think for me, the trust-based system works really well. But really, thank you very much. I'll open it up for questions now. Some of you have sent questions on chat.
Do you want me to tackle the questions in the chat? I can see them now.
Yeah.
Okay. Ruth, I'm also so glad that you're self-employed. It is a privilege. Can your boss take screenshots when your computer is closed? No, it can't. So I'm sure if you were being subject to these measures, you would learn to close your laptop much more regularly because you'd be